Welcome everyone to another live episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge on an area of law that we practice in. Today, we're joined by our staff attorney in Columbia, Julianne Castro, who is our lead attorney in the probate area. And she's going to be talking about the ABCs of probate law. So we're really excited about that because sometimes we talk in too big of a terms, and this will hopefully be a way for folks to really understand what the heck is going on when someone passes away and what you need to do with probate court. So welcome, Julianne.
Hello.
Before we get started, I do want to remind everyone that this is just general information for the public. It's not legal advice, so don't be thinking that we're your attorney. We're just trying to help out with some good information, but Julianne can answer questions at the conclusion of her presentation if they're just general questions. So look at your screen and scan that QR code if you haven't done it before, so you can sign up for future episodes of Level Up Law. You can suggest an episode of Level Up Law, and all of the information to apply for our services here at South Carolina Legal Services, if you need that help or help in the probate area or any other area that we practice in, we'll have all of that at the end of the presentation for you. So I'm Susan Ingalls. I'm here in the Greenville office of Legal Services, and we got our producer Kenneth Elliott in the background. He's making sure that everything is working properly, which it is. And just remind everybody that Kenneth is recording this and will upload it to our YouTube channel. So if you want to go back and review or anything like that, you'll be able to do that within 24 hours for sure. So thanks for that, Kenneth. Thanks for being with us, Julianne. I'm going to go ahead and turn it over to you.
All right, thank you. So today I'm pretty much going to want to discuss the ABCs of probate court. Usually when we have people come into our office, they are just so confused about where to even begin the probate process. There are many words that are used in the pleadings or used when you go to the clerk's office that a lot of people don't understand. So the main takeaway that I want everyone to get from this presentation is that you can do this. A really common misconception is that you absolutely need to have an attorney. And most of the time, you don't need an attorney to do this process. You can do about 99% of this without an attorney. And I'll talk about that 1% where it probably suggests that you do get one. But you can do this without an attorney. There are very rare circumstances where you have a very complex estate. But most of the time, as long as you kind of get an understanding of the words, an understanding of what to expect with the probate court itself, and then also with the process of possibly being the personal representative, which I'll explain later, then this is something that most people will be able to tackle on their own. And like I said, you don't have to get an attorney. You also don't need to go to the probate court. Many of these forms can be found online, so you don't have to wait to get a ride to go to the clerk's office to ask them for forms. You don't have to go there every time you need something. A lot of these forms that you need are right at your fingertips, and I'll show you how to get that. Okay, so how do I get these forms? So South Carolina has a really nice website. It's called secourts.org. And it has a lot of information on there. Let's say you have a hearing coming up. If you want to look at the calendar is on there. But for the purposes of this presentation, I'll show you how to get the forms that you need. So if you look at the bottom right towards the side, you'll see where I've highlighted court forms. That's where you're going to want to click to get the forms that you need. It'll bring you to this page. There are several different options. So one of them is you can search by a specific form number. Another one is you can use a specific keyword. The easiest thing to do is just select it by court type. So once you select the little dialog box and the little drop-down menu comes up, you'll be able to go choose which court you want to get the forms for. So there's family court, there's common pleas, all these different courts. What you want is probate court. And once you get that, you just select submit. So this is the next slide that you're going to get. Once you get to this page, this is going to show you all of the forms you may ever need if you were in probate court. There's about, I would say about like 50 different forms on here. You can get it in PDF or Word form, but these are all the same forms that you would get if you were going to go to the clerk's office. So like I said, you don't have to wait to go to the courthouse. You can get it yourself. You can start working on that paperwork. So that way, when you're actually at the clerk's office, all they might have to do is just sign something or get it certified and clocked in with the court. So now to the main idea of this presentation, the ABCs. We're going to give you the baseline knowledge so that way you are comfortable with stepping into the probate court and beginning this process. So what exactly does it mean to probate? So this might mean that you are executing a deceased person's will or simply managing the deceased person's assets and debt. So let's say that someone passed away. So you might be giving away the specific items that they wanted to give to specific people in their will, or you might be taking care of their home or their car, or managing any debts that they may have left behind. Creditor is a party who is owed money. So sometimes the most common things I see are hospitals, credit card companies, and number one is the funeral home. If you open up an estate, the main creditor, the very first one that is going to be paid, is the funeral home. A decedent, another common word that you're going to hear, it simply means that this is the person who passed away. A devotee is a person who gets something in a will. So they're the person that is named in a will. So for example, it says, I am giving my car to Julianne. So I'd be a devotee. Executor, executrix, those are the older kind of terms, and now we use the word personal representative, or PR for short. They all mean that basically this is the person who handles the estate. They handle the paperwork, they manage the assets of the estate, so like the car and the home. They settle the debts of the estate. And this is usually someone that's appointed by the court. And I'll talk about how you might have priority in this circumstance. An heir is a person who inherits from the individual who passed away. So if, let's say that this person did not have a will. So for example, if my mom passed away, then the possible heir would be my dad and then me. Testate means that the person had a will versus intestate, meaning that the person did not have a will. And the testator is basically just the person who signed the will. So this presentation will give you the who, what, when, where, and why of probate. Who should probate the estate? What exactly does it mean when you probate the estate? When should you do it? Where is the proper place to start this process? And why do we believe that you should go ahead and do it? So what exactly is the probate court? So the probate court handles different matters. The ones that we're going to talk about today is, of course, probating estates, but they also handle guardianships and conservatorships. And they mainly follow the rules of the South Carolina Probate Code. This was adopted in 1986, and there's several different articles, and this is Title 62 of the South Carolina Code. So if you were to Google Title 62 South Carolina Code, one of the first things that'll pop up is the South Carolina Probate Code. So if you ever want to know what the laws are that the probate court follows, all you have to do is look that up and you'll have it right at your fingertips. You'll see what attorneys, if there's an attorney that's involved in this case, you'll see what they're citing. You'll see what is being cited in some of these forms, just so you have an understanding of where it's coming from. So when is probate necessary? So I'm going to break this up into whether you should do a small estate versus a full estate, or maybe you shouldn't do it at all. So let's talk about the small estate first. So this is going to be 420ES, the form that is on the SC Courts page. And basically, it is the affidavit to open up the small estate. You can do this if the individual who passed away did not own any real estate, the value of the personal property does not exceed $25,000, and you can file the paperwork 30 days after the death of that individual. So if all of those apply, you may qualify for a small estate. But if it does not apply, then you should do a full estate. So if this person owned a house, or they owned, let's say, $50,000 in personal property, that is something that you would have to go through a full estate for. Now, if the person owned nothing at all, this is usually when I would say it might not even be worth it to probate the estate, but you should definitely make sure that you consult with an attorney on that, just so we can kind of investigate to see what is in there, and if probate is actually necessary in your case. So something that I commonly hear is, I've heard that probate is important if there's a will, but what exactly is a will? So you might have something in your house and you don't even know it's a will. To make a valid will in South Carolina, you really only need two things. So the person who wrote the will, the testator, must sign the will, and they must have two witnesses. Another common misconception is, well, I got the will notarized, so that must mean that it's legal. That's not necessarily the case. So a lot of notaries are not lawyers, and they don't have to be lawyers, so they can't give legal advice. Just because you have something notarized, that does not mean that it is legally enforceable or that it's done properly. Basically, a notary just makes sure that the person who is signing the document is who they say they are. So I would just say it's best to play it safe. If you want to make sure that your will is valid, I suggest that you consult with an attorney to make sure that it fits the requirements of South Carolina. So what should you do if you have someone's will? So you can do one of two things. You can either go ahead and probate the will using Form 300 ES, or file it with the court. So let's say you're just filing it with the court. So you would be using Form 306 ES, which you see right here on the right. Basically, when you're filing a will with the court, you're just providing them with information about where the will is, who has it, and a way for them to kind of document that. And I would say that if you do have something that you believe is someone's will, just play it safe, go ahead and file it. Per South Carolina law, whoever has a will and knowledge of death has 30 days to file the will with the court. You may be held liable if you intentionally, fraudulently destroy, hide, or fail to give the will to the probate court. And what if you have the most recent will and someone tries to file an old one? Or what if the family members don't have a copy of the will, or the personal representative doesn't have the will? If you believe you have someone's will, whether it's a copy or original, go ahead and try to file it. So that way the court is put on notice. It's up to the probate court to then decide whether to admit a copy or whether this is the original, and they have a whole process for that. But just play it safe and go ahead and file. Now, let's say that you want to probate the estate. So how long do you have to probate the estate? Per South Carolina law, you have no more than 10 years after the date of the decedent's death. After 10 years, you have to do something called a petition to determine heirs. But for the purposes of this presentation, let's just assume that you're within the 10 years. So how do you begin? So apply using Form 300 ES, that is the application to probate the estate. It's also on sccourts.org. You should gather the following documents. Some counties don't require you to have an obituary, but it's best to just go ahead and have it, because some counties actually do ask for it and they won't let you continue until you file that obituary. You need to get a certified copy of the death certificate, a copy of your ID, the original will. So if you have a copy, make sure you try to find the original. The funeral bill. If the bill has been zeroed out, meaning it's been fully paid, it's very important that they have that. If not, just get what you have from the funeral home and make sure you file it with the probate court. If there are any deeds to real estate, titles to cars, mobile homes, that will also need to be filed. And then, where should you file it? So you should file it in the probate court in the county where the decedent, so the person who passed away, died or had property. And that is something that they're going to ask on Form 300, is whether what they call venue is proper. So did the person die in this county, or did they have real estate that they owned in this county? And this is the form right here. So you'd put the county up at the top in the matter of the decedent, so the person who passed away, that's the name who you would put there. Then you would fill out your personal information under 1, and then under 2, it's the decedent's information. So again, the person who passed away. And then, like I said, number 3 is where they're going to determine whether venue is proper in the county. So did they live in that county, or did they have property in that county? Those are the most important things on that page. And this is a 6-page document, and I'll go into what's important in this form. So what I want you to understand is this is used for both formal and informal probate. A lot of the times we have clients that run into situations where they thought that they could do an informal probate, and then the probate court's telling them that they need to do formal, but they don't know which form to use. It's the same thing. It's just that the boxes up at the top, application for informal or petition for formal, those are the 2 things that are going to be checked off that are different. If there is a will, you must list everyone named in the will under 4A. So if there is a will, then the person died testate. So like I said, you will be filing the original copy of the will. The probate court is going to look at that copy of the will, and if there is someone left off of that list under 4A, they're going to return the form back to you. You have to make sure that everyone that is named in that will is listed under 4A. If you need additional space, you can use another piece of paper. If there is no will, you must list the individuals who would inherit under 4B. So that would be the next slide. So if this person died without a will, basically that meant that they died intestate. So if the person died without, let's assume that my mom died without a will. So I would most likely list my dad and me, and I'm an only child. So those are the people who would inherit because my mom did not have a will, and she did not specify that she wanted specific things to go to specific people. Another important question that they're going to ask you is, have you tried looking for the will? More importantly, they're going to ask, have you diligently searched for the will? So basically, they just want to know, if there is no will, have you at least tried looking for it? They may ask you, like, have you looked in safe deposit boxes? Have you asked around? Have you consulted with previous attorneys to see if they have it on file? They just need to know that they're going about this the right way, because if there is a will out there that was properly executed, they don't want to treat this estate as if there was no will at all. Who is getting appointed as the personal representative? This is going to be asked, I think, on the 4th page of this form, and it'll go based off of priority, which we'll discuss later on in this presentation. Sometimes it's named in the will, sometimes it's just based off of the statute, but you'll have to check off a box saying who is getting appointed as a personal representative, whether it's you as the applicant or someone else. You must fill out every single page. There are so many times when the probate court will return this entire packet because everything was not filled out, or there was a certain box filled out. Sometimes individuals don't list the value of personal property or the value of real property. They need to know if you need to do a formal estate or a small estate, or if you need to do an informal estate. Basically, this form is very important in determining what exactly the probate court needs to do to help you get to your end goal. And of course, you must notarize when necessary. That's another thing that's really important. Don't go ahead and sign everything and then submit it to the probate court, because it has to be done in front of a notary, and they cannot sign things that you've already signed. So make sure that you wait to do your signatures on any page that is required until you're in front of a notary. Because like I said, the form will be returned if it is not filled out properly. So all about the PR. So again, what does the PR mean? It means personal representative. So who exactly has priority here? So under South Carolina law, it could be someone that's nominated as a personal representative in a will. And many times you will see it in the will where they will say, I nominate Julianne to be the personal representative. Well, that's easy because then you'll know what to put on that application. But if that's not the case, that is why the statute exists. So who will have second priority? It will be the surviving spouse of the person who passed away, who is a devotee of the decedent. Or third, other devotees of the decedent. So again, devotees means that people that would have inherited. Surviving spouse of the decedent, other heirs who would have qualified. A creditor can even apply 40 days after that person's death. So they can open the estate to try and get payment back, basically. Or they can be nominated by the Department of Revenue. So what if someone has priority, but they don't want to serve? What do you do then? Renunciation. So Form 302 ES is the renunciation of right to administration and or nomination and or waiver of bond. It must be signed by everyone who may have priority. So you may have to give out 10 of these forms to the 10 people that have priority. It must be signed in front of the notary and signed, and they must name the person who is nominated. So let's say that someone is nominating me because I don't exactly have priority, but they have priority. So they will put my name down in the middle section right there where it says name and address. They'll put my information, and then they will sign at the bottom in front of a notary. Now, common misconception with this form is that if you sign this form, you are giving up everything you're entitled to. That is not the case. It says in bold on this form, I am not giving up any interest in the estate or inheritance rights by signing this document. The purpose of this document is to select a personal representative. And again, what does the personal representative do? The personal representative is basically the person that manages all the paperwork. They make sure that the will, that the items in the will are properly distributed. They make sure that everyone is following the decedent's wishes. They're managing the assets, so taking care of the house, taking care of the car. They're taking care of any debts. They are just the one that deals with the probate process. So if you're entitled to something, they can't just take it away from you. That's not what the purpose of this specific form is. So let's say that you get appointed. So now what do you do? Well, remember, you have responsibilities with the court. You have agreed and you have told the court that you are able to collect the assets, you can manage the debts, you can do all the probate paperwork, and you will make sure that you get all the items to the specific people that are in the will. Or if they've agreed, if the family members have agreed to distribute it another way, you have agreed to do that. Don't be irresponsible. If you take money from the estate, you will have to pay it back. The probate court will find out. Just do what you are legally allowed to do by the powers given to you under the probate court and the will. So what should you expect throughout this whole process if you are appointed as personal representative? Well, the first thing is you're going to receive that certificate of appointment. This is very important. You don't have to pay for additional copies from the probate court, but this is what you're going to need if you're the personal representative, because if you need to deal with a mortgage company, you need to show them, hey, I'm the personal representative. I'm allowed to talk to you about this mortgage. Or if you need to go to the bank, I'm the personal representative. I will have access to these things. I need to investigate further to manage the assets of the estate. They will give you these certificates of appointments with stamps from the probate court. Like I said, they're completely free, and you will need that to deal with third parties a lot of the time. You also need to file an inventory and appraisement within 90 days of being appointed. So you have to make sure that this form is done as accurately as possible. There may be times where people make mistakes, and that's okay. That's why they also allow you to amend the inventory and appraisement. But take your time and really try to fill it out correctly, because that's where they get the values of certain things. So for example, they're going to ask for the value of the car or the value of the house. We always suggest getting that value from property taxes. Same thing for personal property. Imagine that you're going to be selling these items at a yard sale. Realistically, what can you get for these items? People tend to have a tendency to overinflate what they believe their items are worth, but they may be worth more to you than to others. So don't place a higher monetary value on your items. And like I said, just use what you find in public records, so the property taxes, and then also think about how much you can really get for this chair or this bed or this cabinet if you were to sell it at a yard sale, because that's the true value of it. You would also have to do an information to heirs and devotees and submit a proof of delivery with that. Basically, it's saying that you're going to be giving certain documents to individuals who may be entitled to something under the will or who may inherit otherwise. It's just a way to show, hey, I'm keeping the people that need to be updated. Depending on when you file, there may be a creditor's claim period, unless the decedent passed away more than 1 year ago. So if they passed away more than 1 year ago, you can actually go ahead and kind of streamline this process, file as many of the pleadings as you need to, and you don't have to wait on that creditor's claim period. You should also expect, if there is real property, that you would need to do a deed of distribution, because who is going to be taking over the decedent's share of that property? I would always suggest that you get an attorney here, because it gets pretty tricky. Do you know how to write that property description? What if you need to do a family settlement agreement because someone else is going to be getting the property that otherwise wouldn't have received it? What is the derivation? Those are all things that attorneys would be able to figure out for you, and they'd be able to help you with. You don't really want to mess that up, because you don't want to mess up the property description later on. And then the end goal is closing out the estate. So what I always suggest with people is to keep open communication with the probate court clerk. They have a lot of knowledge, and although they can't give legal advice, they are able to help you move that process forward and give you the necessary paperwork without telling you what you're legally supposed to do. So what else should you know? This is not going to be a quick process. A lot of people think that they can just file one thing and they'll have the house in their name. That is not true at all. Remember, like I said in the last slide, there may be a creditor's claim period depending on when you file and when that person passed away. So you may be looking at 8 to 12 months here. You may be looking at more if there are issues in the estate. Just do not expect this to be done within a matter of 2 weeks. There will be deadlines. Some of them are statutory deadlines. Some of them are deadlines that are given by the court. This is all for the purpose of making sure that you continue to move things along. It's so easy to just get stuck on one of these forms, and then before you know it, it's been 7 months and nothing's happened. So a lot of the time, the probate court will give you a deadline and say, hey, this is the deadline for filling out this form. Let me know if you have any issues. And they may give you an extension on that deadline if you tell them you're having some issues with that, or that you're seeking an attorney. There will be fees associated with probating the estate. So there will be fees for filing, there are fees for some of the paperwork that you need to get. Just understand that this is not going to be completely free all the time. And another important thing to know is that the will dominates. So if for whatever reason you believe that the person who passed away promised you something at one point in their life, they promised you one of their cars. If that's not put in the will and there is a will that's left behind, you're not going to get that car. What matters is what was written in that will. Again, take a deep breath and understand that you can do this. All the forms are at your fingertips. The probate court clerks are incredibly helpful in helping you move things along, although they can't give legal advice. If you do need legal advice, or if you get to that point where you need a deed of distribution, that's the 1% time that I'm telling you that you need an attorney. If you ever get stuck, I always suggest that you consult with an attorney to help you, because you don't want to mess this up. Right. Does anyone have any questions?
Well, Julianne, one of our viewers asked if they could have a copy of the presentation, and I went ahead and answered that to let folks know that we will link these slides to the YouTube video when it's posted to our YouTube channel. It'll be a PDF of the slides, but yeah, you can get that once this is posted. There's another question there if you want to take that.
Oh. I'm not sure if I can see the presentation.
What if the other person listed in the will is deceased?
Okay. So usually depends on how the will is written, but there might be some sort of statement that comes after it that says, like, let's say, for example, my mom wants to give the property to my dad. So she'll say, I want to divide the property to Julianne's dad. If Julianne's dad predeceases me, then the property will go to XYZ. If that's not the case, then usually the property will be distributed as if there was no will in that certain circumstance. But there's usually alternatives. Mm-hmm. And that's always why we suggest to update the will, because there are also many times where people will do one will in their lifetime. Let's say they did it in 1970, because that's happened before. And then the personal representative that they chose died. The alternate personal representative also died. All the people they wanted to give the house to died. So if you want the property to go to specific people that you really believe are going to take care of your items, make sure that you go ahead and update that will if there are any major life changes, such as someone dying, someone maybe getting divorced, anything major. It shouldn't be that much of an issue to update the will.
Yeah, these are such good questions here. And one other thing I think about, if the person listed in the will is deceased, they may or may not have had their own estate when they died, and that certainly is a factor.
Yes, that is a factor, because we've also had instances where people have died, and it's been more than 10 years. So what happens after 10 years? Well, you have to do the petition to determine heirs, and it will just delay everything in the process, all because you wanted to probate this one estate right here.
Right, right. I guess it's just the facts of every case. Can you briefly explain, and I know you did this, but it's like maybe a little quick review of the difference between the small estate and the large estate, just kind of in general.
Okay, so basically small estate. So let's say that I died, I didn't own a home, I really just had the clothes on my back, so less than $25,000. But I had a little bit in my bank account, maybe $1,000. So someone can open up a small estate to go ahead and try to claim that. But let's say that I owned a home, and maybe I even had a little bit more money in my bank account. But usually, if you just have real property, you'll have to do the full estate. But those are the main differences. So if the person that passed away had less than $25,000 value in their personal property, they died more than 30 days ago, and they don't have real property, that is when you can do the small estate. And it's a lot less paperwork, because they don't have all those other things that you would see in a full estate, such as like the property, the personal property, maybe more than one bank account. There might be some other savings account somewhere, but that's the purpose of the small estate.
Yeah, and there's a follow-up question here that says, so with real property, it's always a large estate?
It's going to be a full estate if there's real property in that person's name.
Yeah, no matter what the value.
Right.
Yeah. Okay, let's see. Is the will filed only after the author of the will is deceased?
No. So sometimes we have people that decide that they want to go ahead and file their will, which is fine. You can file it whenever. It's just that if you know that it hasn't been filed and you have it in your custody and you know that person has died, you have that duty under South Carolina law to go ahead and file it. But there are many times that people don't even file the will until they go ahead and probate the estate, and that's when it's put on file with the probate court. But you don't have to wait.
Mm-hmm. Of course, if you change your will, I guess that you're constantly filing.
Yeah, and you got to update
some people like to
that.
change their will a lot, don't they? Okay, what if the writer of the will died in one county and owned property in a different county?
So you can open it in one county and do a smaller like proceeding in that second county where they might have had something else. Again, it kind of depends on whether this is in South Carolina or whether it's in another state. But if we're just talking about South Carolina, you can do a little supplemental like proceeding kind of thing in another county within South Carolina and let them know, hey, so I did probate the full estate in this county and something else happened that I was just made aware of. And just let the probate court know in that specific county what you need to do. And they can, best way to describe it is just like open it temporarily just to kind of handle that issue. And then they'll resolve it.
Yeah, so like the probate estate is open in the county where they died, but then someone says which county is the probate estate filed in. But then, so if they have like real estate in another county, it's just a matter of filing sort of a copy of that estate from the county where they opened it. So that if somebody, I guess, wants to buy the property that's in that other county, they need to know that the owner of it has died. And the only way to do that is to have that other thing filed, like you said. Okay, can court staff provide assistance with identifying the correct forms to file based on the estate type?
Yes. So they can give you the correct forms that you need, and this is a common example. Someone comes in and they say that they need to just open up a small estate. There's no big deal, you know. There's just a little piece of property. Well, the probate court is going to tell you, well, you know, you can't do that if there's a piece of property. Here are the forms that you're actually going to need. Now, they can't go step by step and tell you this is what you need to put in box 4A and this is what you need to put in box 4B. They might tell you that something's left off, but they can only go so far before it's considered legal advice. And if they ever tell you, you know, you need to consult with an attorney, it's not that they don't want to help you, but they can't give legal advice if they're not attorneys. And it's always best to just have an attorney at least look at the documents when you're first starting out and let you know, this is what you should put in these sections. That way you know it's done properly, because it's better to just go ahead and do that rather than going back and forth with the probate court, because that can take a long time.
Like, that's all the questions. Those were all really good questions, I thought. So thanks to our audience for really, you know, participating in the dialogue here. But it looks like that's all the questions for now. I'll keep an eye on that as we close out. But that does conclude Julianne's presentation for today. So Julianne Castro from our Columbia office, thank you so much. That was really a terrific presentation and really good information about the basics of probate law. And we thank our audience as well. We hope the information is helpful to you. And before I forget to do this, there's one more question. I think I can answer it, but we can both answer it. When determining which state and county to file the probate, does the decedent's domicile matter? I think the answer to that is yes. That's where you file the estate, right?
Right. Yeah. So domicile just basically means where the person lives. So that's going to be in I believe it's section 3. It's on the bottom of that first page, and it asks you whether that person was domiciled in South Carolina or in this county, and then you'd have to put the address that they lived at or were living at before they passed away, and the county that they were living in. So if they were living in let's say they passed away in a hospital or something, and they were there for like a month, I'm not going to put the hospital's address. I put the address of where they were actually living before they had to go to the hospital. And that would determine venue. And that's their domicile, is basically where they live.
Great point about the hospital, for sure. Well,
Yeah.
as I mentioned to everyone at the beginning, we will post a recording of today's episode on our YouTube channel, as well as a link to the presentation slides. Just look up Level Up Law playlist on our YouTube channel at SC Legal Services, and just put in ABCs of probate code. Now, when you go there to our YouTube page, if you have not checked the subscribe button there before, dear viewers, go ahead and do that now. We want everybody to check out all the information that we have there. But also, if you subscribe, you will get notifications every time we post a new video, whether it's Level Up Law or any other of the video resources that we produce here at South Carolina Legal Services and that we share with our viewers. And I'm speaking now to not just the live viewers, but also the viewers that are watching that replay. And listen, while you're there, if you found this video helpful, and I'm sure you did, be sure and share it out to others, because even if you don't need it, you may know someone who does, for sure. And also be sure to check out our other social media. You can see it here on the screen. Everything is at South Carolina or at SC Legal Services now on our social media, so you can check those out there. And we also still have that QR code on your screen, so you can scan that and sign up for our newsletter, get educational resources, and even donate to South Carolina Legal Services. We are a nonprofit law firm. We don't charge for our services. You just have to be eligible. And so definitely check it out here on the screen. You can apply for our services by telephone or online, which is 24/7. You can do that at night in your pajamas. So either way, we want you to apply and see if we can do something to help you. Now, be sure and tune in next week for another live episode of Level Up Law, when our housing law unit head, Matt Billingsley, will be showing us his reaction to a film of an eviction hearing. It'll be called Legal Aid Lawyer Reacts to an Eviction Hearing. And it promises to be really good. The last time we did a Legal Aid Lawyer Reacts, it was to an order of protection. Nicole Jackson down there in the Columbia office did that one. And listen, that was only 10 months ago. It's got 3,800 views. So those are really good ones to watch, as are all of our other videos there on Level Up Law. Hopefully they're helping everybody that needs some good general information about the law in South Carolina. So Julianne Castro, thank you so much again for a great presentation. Thanks to our producer in the background there, Kenneth Elliott, and to you, our viewers, both live and on the replay. Take care. That concludes today's webinar. See you, everybody.